And welcome back. The Gauteng High Court has ruled that there are no compelling reasons for leave to appeal to be granted to Ace Magashule. The suspended ANC Secretary-General approached the court to appeal against a court judgment that upheld his suspension from the ruling party. The Gauteng High Court in Johannesburg dismissed Magashule's application with costs. Sanusha Naidu is a political analyst and joins us now. Sanusha, very good evening to you and thank you so much for speaking to us. So let's just look at what has happened here. The court rejected every ground, the argument for leave to appeal, and saying that this also includes the contention that the full bench was biased. What test would the judges have used to reach this conclusion?
Good evening to you and the viewers. I think what is interesting in this case particularly is whether or not the court wants to veer into the lane of determining the internal process of the political party. Now, that is where, for me, it's an interesting precedent set where if they have to go into it and start getting into the nitty-gritty of the ANC's constitution and start determining how that constitution should be interpreted in view of Mr. Ace Magashule's application that it was unconstitutional, not by the Republic of the country, but rather the ANC's constitution as well, that it essentially then puts the judiciary in a very unprecedented position. So I think they also don't have case law in this, particularly in terms of determining to what or limited case law, let me just say that, because he's asking them to determine that the way in which the processes unfolded in the ANC was essentially biased towards him. And I think this makes the courts very nervous in the sense that they get almost caught up in a political internal battle that becomes messy for them. And so they just don't want to get involved in that, because then it becomes open season for the judiciary, where everybody then can come to the judiciary and say, well, what has happened to me is essentially unconstitutional and I feel that I've been biased. So I think if you go back to the first judgment of Mr. Ace Magashule's application, it was interesting to see that in that judgment, they spoke about the voluntary membership in an organization. And that's what is important. Once you make that step into that membership, you actually take on their kinds of rules and processes.
But Mr. Magashule himself also cast aspersions on the judiciary's independence by accusing them of bias. So the fact that the judges have ruled and dismissed these allegations, as they say, perceived or real, what will be the ruling? What will the impact of the ruling be on this conjecture, the fact that it's been bandied about within certain quarters?
I think has always been the kind of default strategy. If individuals don't get their way or don't see how the judiciary sees their interpretation of issues, then it becomes a contestation of whether the judiciary is objective, impartial, or whether it's biased. And I think that's that's very dangerous, because as much as you have to look at the legal ambit of this whole process in terms of the judiciary and the process it followed, you can't go around banding these aspersions on the judiciary, because then you're not playing fair, in my opinion.
So these latest developments come after President Cyril Ramaphosa also allowed a relaxation of restrictions. And I'm wondering, will these type of issues find themselves on the campaign trail? And how does that trail look like for political parties in the next couple of days? So we're down to alert level 2, which isn't as easy in terms of allowance as 1, but it certainly is easier than 3.
Definitely. I think there is a bit of flexibility, a bit of room for maneuver. You have a easing of the regulations with regard to gatherings. You've got the curfew that also eases up a little bit, although you've got to abide by that. And it allows political parties to have a little bit more, not complete face-to-face, but to have face-to-face engagements with regard to their electoral campaigning. I think the issue you raised, and considering how election campaigns have been conducted in the past, I think it's also an opportunity to look at how political parties become innovative. How do they use different spaces? It has been argued that they could use social media. But I think we've got to also be careful in assuming that social media is the go-to strategy. Not everybody on social media may have the same kind of traction, or not everybody on social media will take to political parties. We've also got to worry about certain social media platforms where there is definitely questions about whether you could use the platform for lobbying and political campaigning. I mean, in terms of privacy and so forth, there's a whole lot of issues there that need to be looked at. I think in terms of where political parties go, definitely this issue will be raised. I think we've already seen other political parties raising questions about the efficacy of the ruling party and its ability to govern. And I think that has been one of those issues that has always remained a key strategy for opposition parties. But again, the challenge is, will it make a difference? Because at the end of the day, I don't think people need to know that the ruling party is not governing in the way that is productive and effective. They know that because they experience it every single day. Opposition parties need to be much more innovative than that.
We've seen that the IEC has filed answering affidavits to the DA's application on the reopening of the candidates list process. How do you foresee this impacting the political playing field, given the fact that there has been a lot of criticism against the IEC for taking this decision, but it's been said the fact that independents will actually benefit a great deal from this?
Yeah, I think the IEC, I think it was the IEC CEO was giving an interview over the weekend, and he did mention that they have interpreted sections of the Constitution, sections of the Electoral Act, in terms of where they feel that they are in the legal ambit to basically open up the registration process for candidates. And there's also this gray area around what the actual Constitutional Court decision was. Did they actually say you only can open up the voter registration process because that needs to be the timetable that needs to be looked at, or do you also have to open up the candidates process? And I think it's a question of interpretation and translation. And I think at this point in time, the DA's application is really about saying that those two are separate issues in terms of impact and how it needs to be interpreted. I think what's going to happen here is whether or not this will impact on the IEC's election timetable, because they have a very small window of opportunity, crunch time.
Sanusha, quick and final question. What do you think will influence a higher voter turnout?
At this point, it's very uncertain and undecided. I think the question is, if people believe that the IEC is that trust institution, they believe that the IEC does conduct elections in a free and fair way, that could be a motivation to go out and vote. But I also think the motivation to go out and vote is to say that your vote is important. If you want to see the change and you want to see the real value in your democracy, then you go out and vote. But I think right now, morale is really low in the country.
Thank you so much for your time and insight. Sanusha Naidu is a political analyst speaking to us on various political developments. Now,